In recent weeks, a series of seemingly unrelated court decisions, enforcement actions, and executive orders have created confusion about the line between what's legal and what's illegal, what's permissible and what's actionable. The confusion is understandable because the compliance landscape is changing. This segment of Drop the Bowtie will be the first in a series as we unpack recent events and their impact on the dealership community. Let's begin. In April of 2025, President Trump issued an executive order entitled Restoring Equality of Opportunity and Meritocracy. I quote from it here. A bedrock principle of the United States is that all citizens are treated equally under the law. This principle guarantees equality of opportunity, not equal outcomes. Disparate impact liability holds that a near insurmountable presumption of unlawful discrimination exists where there are any differences in outcomes in certain circumstances among different races, sexes, or similar groups, even if there is no facially discriminatory policy or practice or discriminatory intent involved, and even if everyone has an equal opportunity to succeed. It not only undermines our national values, but also runs contrary to equal protection under the law and therefore violates our Constitution. Disparate impact liability imperils the effectiveness of civil rights laws by mandating rather than prescribing discrimination. As the Supreme Court put it, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. On that foundation, President Trump declared the policy of his administration. It is the policy of the United States to eliminate the use of disparate impact liability in all contexts to the maximum degree possible to avoid violating the Constitution, federal civil rights laws, and basic American ideals. And then, finally, the kill shot. All agencies shall deprioritize enforcement of all statutes and regulations to the extent they include disparate impact liability. Okay, so what does all this mean? And what does it mean for dealers? Remember that there are two varieties of discrimination: disparate treatment and disparate impact. Irish need not apply is one example of disparate treatment, actual discrimination based on an immutable characteristic. But imagine a circumstance where employment was equally available to all, but only a small number of Irish get those jobs. The facially neutral policy seems to have some built-in bias against the Irish. That is called disparate impact discrimination, and it can exist in the eye of the beholder. It is measured not by an unequal opportunity, but by an unequal outcome. It is this concept of equality that the current administration is fighting. A link to the executive order is included below. How should dealers respond to this shift in approach and enforcement? Very carefully. We'll discuss that in our next episode. For Drop the Bowtie, I'm Jim Ganther. Thanks for watching.